Good afternoon. We're taking a look at my desktop here. On the left side of the screen, we have the statement from the ATF, and in this video, I'm just going to read this statement and then I'll leave it at that, and without any commentary or anything, just for people that might have trouble seeing or reading it normally. So it's a PDF document from the ATF, and it starts off with the document is scheduled to be published in the Federal Register on December 18th, 2020, and is available online at this address, federalregister.gov/D/2020-27857, and on govinfo.gov, which are two URLs. Then I'm just going to read what it says. It says, Department of Justice, Bureau of Alcohol, Tobacco, Firearms, and Explosives, docket number 2020 R-10. Objective factors for classifying weapons with stabilizing braces. Agency, Bureau of Tobacco and Firearms and Explosives, Department of Justice. Action, notice, request for comment. Summary, the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF, is publishing the objective factors it considers when evaluating firearms with an attached stabilizing brace to determine whether they are considered firearms under the National Firearms Act, the NFA, and or the Gun Control Act, the GCA. ATF publishes this notice to inform and invite comment from the industry and public on the proposed guidance, objective factors for classifying weapons with stabilizing braces prior to issuing a final document. Upon issuance of final guidance, ATF will provide additional information to aid persons and companies in complying with federal laws and regulations. This notice also outlines ATF's enforcement priorities regarding persons who, prior to the publication of this notice, made or acquired, in good faith, firearms equipped with stabilized braces. Finally, this notice previews ATF's and Department of Justice's plan to subsequently implement a separate process for current possessors of stabilizer-equipped firearms to choose to register such firearms in compliance with the NFA, including an expedited application process and the retroactive exemption of such firearms from the collection of NFA taxes. Next is the dates. Written comments must be postmarked and electronic comments must be submitted on or before. Then it says insert date 14 days after publication in the Federal Register, which was Friday, so this is 13 days left and counting. Commenters should be aware that the electronic federal document management system will not accept comments after midnight Eastern time on the last day of the comment period. Addresses. You may submit comments identified by docket number ATF 2020 R-10 by any of the following methods. Federal e-rulemaking portal at a URL regulations.gov. You follow the instructions for submitting comments there. By mail to the Office of Regulatory Affairs, Enforcement Programs and Services, Bureau of Alcohol, Tobacco and Firearms, 99 New York Avenue Northeast, mail stop 6N518, Washington, D.C. 20226. Attention, ATF 2020 R-10. The fax number is 202-648-9741. Instructions. All submissions received must include the agency name and docket number, ATF 2020 R-10. All properly completed comments received will be posted without change to the federal e-rulemaking portal at regulations.gov, including any personal information provided. For detailed instructions on submitting comments and additional information on the rulemaking process, see the Public Participation heading of the supplementary information of this document. For further information, contact Andrew Lang, Office of Regulatory Affairs, Enforcement Programs and Services, Bureau of Alcohol, Tobacco and Firearms and Explosives, U.S. Department of Justice, 99 New York Avenue Northeast, mail stop 6N-518, Washington, D.C. 20226. Telephone 202-648-7070. This is not a toll-free number. Supplementary information. And then it goes on to the second page. First heading, background. The Attorney General is responsible for enforcing the NFA, GCA, and the Arms Export Control Act, AECA. The Attorney General has delegated the responsibility for administering and enforcing these statutes to the Director of the ATF, subject to the direction of the Attorney General and the Deputy Attorney General. See 28 CFR .130 parentheses A 1 through 2. The ATF Director delegated the authority to classify firearms pursuant to the GCA and NFA to ATF Firearms Technologies Criminal Branch, the FTCB, and the Firearms Technology Industrial Services Branch, the FTISB, within the Firearms and Ammunition Technology Division, FATD, Office of Enforcement Programs, EPS. FATD supports the firearms industry and general public by, among other things, responding to the technical questions and by testing and evaluating firearms submitted to the ATF for classification as to the regulation under the GCA and or the NFA. There is no requirement that the firearms industry or the public submit firearms to the ATF for assessment of the firearm's proper classification. The statutory definition of firearm under the Gun Control Act and the National Firearms Act are different. As a result, whether an item meets the definition of firearm under the GCA or the NFA affects how it will be regulated under federal law. For example, the GCA restricts the transportation, sale, and delivery of short-barreled shotguns and short-barreled rifles, 18 U.S.C. 922A4 and B4. Shotguns having a barrel or barrels of less than 18 inches in length, and rifles having, going on the third page, barrel or barrels less than 16 inches in length, and certain weapons made from shotguns and firearms are firearms as defined by the NFA and are subject to regulation and taxes. 26 U.S.C. 5845A. Therefore, FATD's classification of particular firearms allows industry members to plan, develop, and distribute products in compliance with the law, thereby reducing their risk of incurring criminal or civil penalties or the potential for costly corrective actions, including a possible recall by the manufacturer. Generally, when FATD evaluates a firearm sample, it examines its overall configuration, physical characteristics, objective design features that are relevant under the statutory definitions of the GCA and NFA, and any other information that directly affects the classification of a particular firearm sample. Even though firearms may appear to have similar features, an ATF classification pertains only to the particular sample submitted. Because variations in submissions, applications, statutes, judicial interpretations of these statutes, and the manufacturer or maker's intent, the objective design features supporting that intent make the general applicability of any particular classification exceedingly rare. In recent years, some manufacturers have produced and sold devices designed to be attached to large and or heavy pistols which are marketed to help the shooter stabilize his or her arm to support single-hand firing braces. ATF was advised by the first manufacturer to submit an arm brace for classification that the intent of the arm brace was to facilitate one-hand firing of the AR-15 pistol for those with limited strength, going on to the fourth page, or mobility due to a handicap, and to reduce bruising to the forearm when firing with one hand. According to this manufacturer, the brace concept was inspired by the needs of disabled combat veterans who still enjoy recreational shooting but could not reliably control heavy pistols without assistance. Consequently, ATF agrees that there are legitimate uses for certain stabilizing braces. The GCA and NFA generally regulate firearms and not individual components. As such, ATF does not classify unregulated components or accessories alone. However, components or accessories can affect the overall classification of a firearm because, number one, how a component or accessory is actually used may be relevant in assessing the manufacturer or maker's intent with respect to the design of the firearm. Or two, the design of a component or accessory may result in the firearm falling within a particular statutory definition. Stabilizing braces are one such component or accessory that ATF has encountered. ATF's long-standing and publicly known position is that a firearm does not evade classification under the NFA merely because the firearm is configured with a device marketed as a stabilizing brace or an arm brace. When an accessory and a weapon's objective design features taken together are not consistent with the use of the accessory as an arm brace, that is, not to stabilize a handgun when being operated with one hand, such weapon configured with the accessory may fall within the scope of the NFA. Particularly when the accessory functions as a shoulder stock for the weapon. Accordingly, the ATF must evaluate whether a particular firearm configured with a stabilizing brace bears the objective features of a firearm designed and intended to be fired from the shoulder and thus subject to the NFA on a case-by-case basis. Now we're on to the next page. The purpose of the NFA is to regulate certain weapons likely to be used for criminal purposes. United States versus Thompson Center Company, 504 U.S. 505 517, 1992. ATF cannot ignore design features of a firearm that place it within the scope of the NFA's regulation simply because the manufacturer characterizes or markets a firearm accessory in a manner that does not correspond to its objective design. The characterization of an accessory by the manufacturer, including assertions in advertising, is not dispositive. If ATF's classification of a submitted sample demonstrates that the objective design features of the firearm as configured do not support the manufacturer's supported intent and characterization of the accessory on that particular firearm as a stabilizing brace or arm brace, ATF will classify the firearm based on the objective design features as federal law requires. See Sig Sauer versus Brandon, 826 F3D 598 601 through 2, first CIR 2, first circulated 2016, I think. ATF has observed that the development and production of firearms with arm braces has become more prevalent in the firearms industry, and relatedly, that requests for classifications for this kind of firearm design have also increased. Therefore, ATF is publishing this notice to aid the firearms industry and public in understanding the objective design features that FATD considers when evaluating firearm samples submitted with stabilizing brace or similar attachment. The objective design features ATF considers in determining whether a weapon with an attached stabilizing brace has been designed or redesigned, made or remade, and intended to be fired from the shoulder include, but are not limited to, type and caliber, weight and length. Type and caliber. The type and caliber of a firearm to which the stabilizing brace or similar item is installed. A large caliber firearm that is impractical to fire with one hand because of recoil or other factors, even with an arm brace, is likely to be considered a rifle or shotgun. Weight and length. The weight and length of a firearm used with the stabilizing brace. A firearm that is so heavy that it is impractical to fire or aim with one hand, or that it is so long it is difficult to balance the firearm to fire with one hand, it is likely to be considered a rifle or a shotgun. Length of pull. The length of pull refers to the distance from the trigger to the point at which the stock meets the shoulder. This is a measurement for rifles and shotguns used to accommodate shooters of different sizes. Because an arm brace need only reach the forearm, the distance between the trigger and the back of the brace is generally expected to be shorter than the distance between the trigger and the back of a stock on a weapon designed to be intended to be fired from the shoulder. This measurement is not necessarily determinative of the intent of the manufacturer, but it is used in making an evaluation of the firearm. If a brace is of a length that makes it impractical to attach to the shooter's wrist or forearm, then that may demonstrate that it is not designed as a brace, but rather for shoulder fire. Attachment method. If the method of attachment of the stabilizing brace to include modified stock attachments, extended receiver extensions, and the use of spacers, these items extend the distance between the trigger and the part of the weapon that contacts the shooter, whether it is the stock or stabilizing brace. Use of these items indicates that the weapon is designed and intended to be fired from the shoulder because they extend a stabilizing brace beyond a point that is useful for something other than shoulder support. Stabilizing brace design features. The objective design features of the attached stabilizing brace itself are relevant to the classification of the assembled weapon and include the comparative function of the attachment when utilized as a stabilizing brace compared to its alternative use as a shouldering device. The design of the stabilizing brace compared to known shoulder stock designs. The amount of rear contact surface area of the stabilizing brace that can be used in shouldering the weapon as compared to the surface area necessary for use as a stabilizing brace. The material used to make the attachment that indicates whether the brace is designed to be used as pressed against the shoulder for support or actually used on the arm. Any shared or interchangeable parts with known shoulder stocks. Any other feature of the brace that improves the weapon's effectiveness from shoulder firing position without providing a corresponding benefit to the effectiveness of the stability and support provided by the brace's use on the arm. Aim point. That's two words, aim point. Appropriate aim point when utilizing the attachment as a stabilizing brace. If the aim point when using the arm brace attachment results in an upward or downward trajectory that would not accordingly hit a target, this may indicate the attachment was not designed as a stabilizing brace. A secondary grip. The presence of a secondary grip may indicate the weapon is not a pistol because it is not designed to be held and fired from one hand. Sights and scopes. Incorporation of sights and scopes that possess eye relief incompatible with one-handed firing may indicate that the weapon is not a pistol because they are designed to be used from a shoulder fire position and are incompatible for the single-handed shooting the arm braces are designed and intended for. Peripheral accessories. Installation of peripheral accessories commonly found in rifle and shotguns that may indicate the firearm is not designed and intended to be held with one hand. This includes, but is not limited to, the installation of bipods and monopods that improve the accuracy of heavy weapons, designed and intended to be fired from the shoulder, or the inclusion of a magazine or drum that accepts so many cartridges that it increases the overall weight of the firearm to a degree that it's impractical to fire the firearm with one hand even with the assistance of a stabilizing brace. These factors are known on stabilizing braces and similar attachment. No single factor or combination of factors is necessarily dispositive, and FATD examines each weapon holistically on a case-by-case basis. Because of changes in design or configuration of a weapon or attachment, as well as future changes in technology, this list is not exhaustive, and other factors may become relevant to a weapon's classification. Moreover, in addition to the objective design features of a submitted sample, FATD also considers the marketing of both the item and the firearm to which it is attached compared to the manufacturer's statement of intent when submitting an item. FATD has found that manufacturers sometimes assert that a device is a stabilizing brace when submitting a firearm for classification. The same manufacturers will then advertise their products as devices that permit their customers to fire their pistols from the shoulder, that is, making a short barrel rifle, without complying with requirements of the NFA. This is far from the incidental use of an arm brace as a shouldering device as described in the ATF's 2017 guidance, see footnote 8. But it is instead marketing material that directly contradicts the purpose or intent that the manufacturers conveyed to the ATF. Although not a determinative factor, the actual use by members of the firearms industry, firearms writers, and the general public may provide further indication of the design and intent. These sources provide insight into the ways that manufacturers market their products. Finally, although the above are not the most common objective factors that demonstrate the design and intent of a manufacturer or maker, other factors may be relevant. For example, if FATD classified a firearm with an arm brace as a pistol, that classification would be subject to FATD's review if the manufacturer sold the product with the instruction that the weapon is actually designed to be intended to be fired from the shoulder. This compilation of relevant objective factors is consistent with what has been applied in evaluations of firearms with an attached stabilizing brace previously conducted by FATD at the request of the firearms industry. By setting out these factors in this notice, ATF is ensuring members of the public are equally aware of the criteria when considering the making or purchase of a firearm. As explained above, FATD's classifications allow industry members to plan, develop, and distribute products that comply with the law, and thereby reduce the risk of incurring criminal or civil penalties or potentially costly corrective actions, including a possible recall by the manufacturer. In order to ensure consistency in classifying firearms, FATD uses the following procedure. A firearm voluntarily submitted to FTISB for classification is assigned to a firearms enforcement officer, FEO, who evaluates the firearm. This may include disassembly, test firing, or other processes necessary to determine whether a submission falls under the purview of the NFA, GCA, AECA, That FEO produces a draft report, and that report is peer-reviewed by another qualified FEO and includes a review of the steps taken in the evaluation, the analysis, and the conclusions. Therefore, it is not the case that a single FEO is solely responsible for a particular classification. Because of this, prior to any necessary legal review and before classification letter is signed and finalized, at least 2 FEOs have reviewed the submission. No classification will depend on the physical attributes of a particular FEO, including, for example, whether a firearm is too heavy to be held or fired in a single hand by an individual examiner, as all FEOs apply the evaluation factors objectively, not subjectively, based on objective features of the submission that demonstrate, in the present case, the design of the weapon and the intent of the manufacturer. After the review by 2 FEOs, the classification is then reviewed by the Chief, FTISB, in order to ensure consistency. On August 19, 2020, the Department of Justice, DOJ, published regulations defining guidance documents and required procedures that the department and its components must follow to issue guidance documents consistent with Executive Order 13891C 28 CFR 50.26. The regulation defines the term guidance document as an agency statement of general applicability intended to have future effect on the behavior of regulated parties that sets forth I, the policy on a statutory, regulatory, or technical issue, or II, an interpretation of a statute or regulation. 28 CFR 50.26A1. As ATF started to receive samples of firearms regulated with an arm brace for classification, FATD applied objective factors to interpret the NFA and the GCA definitions of firearm to determine when attachment of an accessory purporting to be a stabilizing brace to a specific firearm results in a configuration subject to the provisions of the NFA. Due to the rise of firearms configured in this manner and a correlating increase in the number of classification requests from industry, ATF is publishing this list of objective factors it considers when classifying such firearms, including an explanation as to why those factors are important, to aid industry and the public in understanding ATF's interpretation and application of the NFA and GCA definition of firearm when evaluating these types of firearms configurations. Although there is no requirement that the guidance document be published for notice and comment, ATF has decided to publish the proposed objective factors in the Federal Register for a brief comment period, giving the public interest surrounding these issues. ATF will consider the comments it receives before finalizing this guidance. ATF recognizes that before issuance of this notice there was a misunderstanding by some that pistols assembled with any item purported to be a stabilizing brace still would be considered a pistol regardless of other characteristics. The objective factors discussed here make clear that while some stabilizing braces may lawfully be used on pistols without bringing the firearm within the purview of the NFA, it is not necessarily the case for every pistol because some firearms are configured or have characteristics such that they meet the statutory definition of rifle or shotgun. Hereafter, affected stabilizer-equipped firearms. ATF understands that most individuals who acquired affected stabilizer-equipped firearms did so in good faith. Reliance on representations made by those selling the stabilizing braces or firearms that those firearms were not subject to the NFA. Consequently, following the issue of this notice, ATF and DOJ plan to implement a separate process by which current possessors of affected stabilizer-equipped firearms may choose to register such firearms to be compliant with the NFA. As part of that process, ATF plans to expedite processing of these applications, and ATF has been informed that the Attorney General plans retroactively to exempt such firearms from the collection of NFA taxes if they were made or acquired prior to the publication of this notice in good faith. This separate process may include the following options: registering the firearm in compliance with the NFA, described above, permanently removing the stabilizing brace from the firearm and disposing of it, replacing the barrel of the firearm 16 inches or greater for a rifle or 18 inches or greater for a shotgun, surrendering the firearm to ATF, or destroying the firearm. Until that process is separately implemented and absent a substantial public safety concern, ATF will exercise its enforcement discretion not to enforce the registration provisions of the NFA against any person before publication of this notice in good faith acquired, transferred, made, manufactured, or processed an affected stabilizer equipped firearms. This document is not, I'm on the page I'm on. Getting down there. Let's go towards the end. The document is not an administrative determination that in any particular weapon equipped with a stabilizing brace is a firearm under the NFA. To the extent that the ATF director subsequently issues such a determination, the ATF director, at the direction of the Attorney General, plans retroactively to exempt such firearms from the collection of NFA taxes, provided those firearms were made or acquired in good faith prior to the publication of this notice. See 26 U.S.C. 7805. The contents of this document do not have the force of law and are not meant to bind the public in any way. This document is intended to provide clarity to the public regarding existing requirements under the law or department policies. This guidance does not alter in any way the department's authority to enforce federal law and is intended to, does not, and may not be relied upon to create any rights, substantive or procedural, enforceable at law by any party in any matter, civil or criminal. Public participation. A. Comments sought. ATF is accepting comments from all interested persons on the use of objective factors listed in this document. All comments must reference this document's docket number, ATF 2020 R-10. Be legible and include commenter's complete first and last name and full mailing address. ATF will not consider or respond to comments that do not meet these requirements or comments containing excessive profanity. Comments that do not meet these criteria will not be considered. ATF will not retain anonymous comments and those containing excessive profanity as part of this administrative record, but will not publish such record. ATF will retain anonymous comments and those containing excessive profanity as part of this administrative record, but will not publish such documents on regulations.gov. ATF will treat all comments as originals and will not acknowledge receipt of comments. In addition, if ATF cannot read your comment due to technical difficulties and cannot contact you for clarification, ATF may not be able to consider your comment. ATF will carefully consider all comments as appropriate received on or before the closing date and will give comments after that date the same consideration if practical to do so, but assurance of consideration cannot be given except as to comments received on or before the closing date. Confidentiality. B. Confidentiality. ATF will make all comments meeting the requirements of this section, whether submitted electronically or on paper, available for public viewing at ATF and on the internet through the federal e-rulemaking portal and subject to Freedom of Information Act 5 U.S.C. 5512. Commenters who do not want their name or other personal identifying information posted on the internet should submit comments by mail or facsimile, along with a separate cover sheet containing their personal identifying information. Both the cover sheet and the comment must reference this docket number, 2020 R-10. For comments submitted by mail or facsimile, information contained on the cover sheet will not appear when posted on the internet, but any personal identifying information that appears within a comment will not be redacted by ATF and it will appear on the internet. A commenter may submit to the ATF information identified as proprietary or confidential business information. The commenter shall place any portion of a comment that is proprietary or confidential business information under law on pages separate from the balance of the comment, with each page prominently marked proprietary or confidential business information at the top of the page. ATF will not make proprietary or confidential business information submitted in compliance with these instructions available when disclosing the comments that it received, but it will disclose that the commenter provided proprietary or confidential business information that ATF is holding in a separate file to which the public does not have access. If ATF receives a request to examine or copy this information, it will treat it as any other request under the Freedom of Information Act. In addition, ATF will disclose such proprietary or confidential business information to the extent required by other legal process. C. Submitting comments. Submit comments, but do not submit the same comment multiple times or by more than one method. Hand-delivered comments will not be accepted. The Federal e-rulemaking portal. ATF recommends that you submit your comments to the ATF via the federal e-rulemaking portal at www.regulations.gov and follow the instructions. Comments will be posted within a few days of being submitted. However, if large volumes of comments are being processed simultaneously, your comment may not be viewable for up to several weeks. Please keep the comment tracking number that is provided after you have successfully uploaded your comment. Mail. Send written comments to the addresses section of this document. Written comments must appear in minimum 12-point font size, 0.17 inches, include the commenter's first and last name and full mailing address, be signed, and may be of any length. Facsimile. Submit comments by facsimile transmission to 202-648-9741. Faxed. Faxed comments must be legible and appear in minimum 12-point font, 0.17 inches, be 8.5 by 11 paper, be signed and contain the commenter's complete first and last name and full mailing address, and be no more than 5 pages long. Signed Regina Lombardo, Acting Director. Then it says docket 2020-27857, filed 12/17/2020. Publication date 12/18/2020, and that's the end of the 15 pages. So with this, I'll wrap this one up. Thank you for paying attention. We'll go back and do more on this in future videos.